So good afternoon, everyone. I wanted to welcome you all to this webinar. I realize we have attendees both on our Zoom link and on our Facebook live streaming. So welcome to everyone. I'm just trying to give everyone a little bit of time to make sure the technology is working. And for anyone who may have to step away, we are also recording this and we will post it at a later time. So really appreciate everyone being here. I'm sorry for a bit of a shuffle and transferring some folks to Facebook Live, but there has been so much interest in this topic that our license couldn't handle it. So we are so grateful for all of our attendees and participants for being here today. And thank you all for joining us. I'm Dr. Holly Krutka, Executive Director of the School of Energy Resources at the University of Wyoming, otherwise known as SER. SER's mission is economic development for the state of Wyoming. With funding from the state, the U.S. Department of Energy through research grants and a variety of other public and private sources, SER has three pillars we use to execute our mission. One is conduct applied energy and policy research. Two is educate students to be tomorrow's leaders in energy. And three is to engage in public outreach like we're doing now. For many years, SER has focused on low carbon technologies, such as carbon capture, use, and storage, as well as technologies and approaches that support advanced energy systems, such as the identification and characterization of rare earth elements and critical minerals here in Wyoming. SER and the state of Wyoming are actively pursuing a future for Wyoming's energy industry in an energy transition. We have no choice. Over 90% of the energy produced in Wyoming is exported. In addition, Wyoming can be disproportionately impacted by federal policy due to nearly half of the surface in Wyoming being owned by the federal government. Before handing over the microphone, I'll make one request. I'd welcome stakeholders to engage with SER. A good start is by following us on social media. You will find that we are relentlessly pursuing pragmatic solutions for the future of Wyoming's energy industry, and we can't do that alone. Today's webinar is focused on the recent executive orders and what they could mean to our state. I'll now welcome SER's Director of Energy Regulation and Policy Analysis, Kipp Coddington, to set the stage and welcome our panelists. Kipp?
Thank you very much, Dr. Krutka. So I am Kipp Coddington, the Director of SER's Center for Energy Regulation and Policy Analysis, and I'm pleased to be the moderator for this panel. So last week, on January 27th, the White House issued an order, and I'm just going to quote from it now, quote, "This order, among other activities, directs the Secretary of the Interior to pause on entering into new oil and natural gas leases on public lands for offshore waters to the extent possible, to launch a rigorous review of all existing leasing and permitting practices related to fossil fuel development on public lands and waters, and to identify steps that can be taken to double renewable energy production from offshore wind by 2030, end quote. And this order followed on an interim order by the acting Secretary of the Interior to just put a general pause on activities, including leasing, as part of the administrative transition underway in Washington, D.C. So as Dr. Krutka had indicated, these issues are not only acutely of importance to the nation, but they're certainly of great importance to the state of Wyoming. So Wyoming has been the top coal producing state since 1986. Wyoming ranks among the top 10 states for both largest natural gas reserves and highest natural gas production. And as of earlier this year, Wyoming was the 8th largest crude oil producing state in the nation in 2018. And again, as Dr. Krutka indicated, much of that production is on federal lands, and the vast bulk of it is exported. So these issues would not only impact energy production as it supplies the nation, but also would have devastating impacts on the state of Wyoming's economy, as we will hear shortly. So with that as background, It is my distinct honor to introduce our panel who will be discussing these issues. And we have three distinguished members. Going first will be SER Professor Tim Considine from the University of Wyoming College of Business, who recently, with funding and support from the Wyoming Energy Authority, conducted an economic assessment of what this type of halt in new oil and gas leasing on federal lands would do. Dr. Considine will be followed by SER Professor Kris Koski, who is an attorney and does a lot of great work for SER and is a leading light in the state and elsewhere in the region on oil and gas issues. Kris will be talking about some of the core legal principles that are raised by virtue of that order from which I just quote. And then Mr. Koski will be followed by Eric Waeckerlin, also an attorney. Eric is with the law firm Brownstein Hyatt Farber Schreck, LLP, and he splits this time between offices in Denver and Cheyenne. And Eric is going to be talking to us also about additional legal issues from a very much a private sector perspective. So with that as background, after the panel goes, each panelist will speak for maybe 10 or 15 minutes, and then we will close out the hour with some Q&A. So with that, I am going to hand the baton over to Dr. Considine. So Tim, you got the con.
Thank you, Kipp, and good afternoon, everyone. I recently completed, as Kipp indicated, a study for the Wyoming Energy Authority on the fiscal and economic impacts of federal oil and gas lease and drilling moratoriums. Today, I'll restrict my comments to the lease moratorium. As many of you know, federal lands are very important for Western states. Nearly half the land area in Wyoming is federal, and 54% of oil production in Wyoming comes from federal lands, and nearly 80% of gas production comes from these federal properties. A lease moratorium reduces investment in new oil and gas wells and results in lower future oil and gas production. Lower investment in production reduces economic activity, employment, and tax revenues, in particular, tax revenues collected from severance taxes, ad valorem taxes, and also lease and bonus payments. What my study found was that restricting federal oil and gas development forgoes significant economic opportunities for income and wealth creation. And my study estimates these opportunity costs. I project future drilling activity on federal and non-federal land and calculate the amount of oil and gas production that would be lost under a leasing ban. The gold areas in both of these charts illustrate or measure the amount of lost federal oil production and federal gas production in the study region, which includes Wyoming, Colorado, Utah, New Mexico, Montana, North Dakota, California, and Alaska. Next slide, please. The fiscal and economic impacts of a lease moratorium are significant. The fiscal impacts basically involve a sharp reduction in tax revenues. In Wyoming alone, average annual tax revenues fall from 300 million to 1.7 billion per year. These tax revenue losses escalate over time. In New Mexico, the losses are even more significant, averaging roughly 900 million per year in the first 5 years under a leasing ban, and if pursued, up to 3.7 billion in the long run. For the entire region, the 8 states that I previously mentioned, the revenue losses average 1.6 billion per year during the first 5 years of a leasing moratorium. And these losses grow to over 11 billion in the out years. These lost tax revenues are not the only negative economic impact from the leasing ban. Employment falls by the tens of thousands per year, and these employment losses escalate over time. And there are significant losses in gross domestic product of 9 to 62 billion per year in the entire study region. Translating to a personal level, this means lower personal income for many individuals. A lease moratorium, therefore, is a costly way to reduce greenhouse gas emissions. I noted in my study that even if you credited all the production losses with emission reductions, the cost of achieving these emission reductions is extraordinarily high, $64 to $196 per ton of avoided emissions. With offsetting production and emission gains from overseas, these pollution abatement costs at least double, which makes it probably the most expensive way to cut greenhouse gas emissions. Next slide, please. So the question I pose for the general public is a leasing moratorium smart policy? Professor James Griffin wrote a book a few years ago called Smart Energy Policy. And he noted that a smart energy policy ensures cheap, clean, and secure energy. A lease moratorium appears to fail at all three tests. It is expensive, imposing significant fiscal and economic losses. It doesn't significantly reduce emissions, if at all. Russia, Saudi Arabia, and other foreign countries could easily offset the production losses under a leasing ban on federal lands. And finally, it leaves us more dependent upon foreign sources of energy. Let's remember the benefits of American oil and gas. It operates under the most stringent environmental standards in the world. American oil and gas now is the world's third largest exporter of low carbon natural gas in the form of liquefied natural gas. This industry also supports high paying jobs in rural communities and generates billions in tax revenues that support local governments, special districts, and these special districts include conservation districts, libraries, healthcare, and other social services. So in conclusion, we may wish to consider a strategy of leveraging the wealth that oil and gas industries create by investing in research and development to improve the environment, not shutting down the industry. And with that, I'll pass my time on to Kris Koski.
Thank you, Dr. Considine. I can say that these numbers are sobering and extremely shocking and should be, concerning to all of us that are proud to call Wyoming and the West home. We all could talk for hours. I'm going to try to keep it short to the point. I'm going to briefly introduce the government's authority to regulate oil and gas development on federal lands, basically under the principal statutes. And Eric Waeckerlin, who has a ton of experience litigating cases with the Department of Interior, is going to get into the finer points as to potential litigation routes to challenge these orders, as well as some tips for what operators can do now in light of these orders. Why this is such a concern to Wyoming from a land perspective, and that's what I do teach is federal lands and other land-based courses, is when you look at the map of Wyoming when it comes to oil and gas development, all our major gas fields are in the west, the Green River Basin, Pinedale Anticline, and so forth. Well, if you go into those gas basins, you really can't put together any oil and gas project that's not going to involve federal lands and minerals. And that's because the vast majority of the western part of the state is in fact federal lands or federally owned minerals. So a leasing ban in that area is going to have absolute devastating effects. When we look towards the eastern part of the state where our oil and gas, where our oil basins are traditionally, and where a lot of our development has been recently, we're talking the Powder River Basin and also the DJ Basin in Laramie and Goshen counties. Well, the large concern of the Powder River Basin, while we do have a lot of lands of private surface, is based on how those lands were originally patented. The federal government reserved the minerals on many of those lands in the Powder River Basin, talking Converse, Campbell, Johnson, and some other counties. So when you're looking to put together an oil and gas drilling unit in the Powder River Basin, it's sometimes nearly impossible to put together any drilling unit that isn't going to include federal lands or federal minerals. So when you're looking at a map of Wyoming, basically you're limited to Laramie County when it comes to oil and gas development, where there isn't a ton of federal minerals or federal potential of oversight. And I do mention that the northern portions of Laramie County, there are in fact federal minerals. So from a standpoint of any oil and gas development, you have to have federal involvement and federal approvals, to be honest. One of the issues of these executive orders is that they may have the opposite effects of what they're intended. As Dr. Considine indicated, that stopping oil and gas development in Wyoming might just push production into other countries. Well, that could be impacting when it comes to CO2 EOR and storage. And that's talking about enhanced oil recovery and actual long-term storage of CO2, which SER has been making quite a bit of headway on over the past few years, including a test well over by the Dry Fork Station. Well, the problem is, if you're going to do any CO2 EOR project or even a storage project, you're going to have likely federal minerals involved. And so that's likely going to require federal oil and gas leases. So perhaps these orders could have a very detrimental effect when it comes to our ability to pursue these CO2 EOR and storage projects. So if you could go to the next slide, I'm going to talk briefly about what it is, what federal authority to regulate oil and gas development here in Wyoming on federal lands and minerals. Really, we're talking about two major congressional acts that are the guiding authority for the Department of Interior, the federal government, when it comes to regulating oil and gas development on federal lands. And we're talking about the Mineral Leasing Act and the Federal Land Policy Management Act. So the Mineral Leasing Act of 1920, it authorizes the Secretary of Interior to lease oil, gas, coal, and a few other minerals on federal lands, phosphate, sodium, and so forth. Well, the BLM is charged with administering the act and leasing all onshore federal lands. So the BLM is in charge of issuing leases on not only BLM lands, but national forest lands. The critical provisions under the Mineral Leasing Act when it comes to what is the authority of the federal government looks to 30 USC 226. And as you can see from the slide, it states that all land subject to disposition may be leased by the Secretary. So that seems to give the Secretary of the Interior some kind of authority over determining whether or not lands are issued for oil and gas leasing. But if you contrast that to the provision that follows, it states, lease sales shall be held for each state where eligible lands are available at least quarterly and more frequently. So that shall seems to be less discretionary. And one reason and I believe a lot of people on this call know that why lease sales are very important for the state is the state of Wyoming, when a parcel of land is leased, the state of Wyoming gets half that lease bonus revenue without even any oil and gas development. And that's hundreds of millions of dollars a year. And once there is development on the lease, the state of Wyoming gets half the royalty, which is 6.25%. The federal lease royalty is 12.5%. The state of Wyoming gets 6.25% of all of the oil and gas royalties on these federal lands. So very, very important when it comes to revenues to the state that mineral leases continue to be issued to allow income revenue to our state, as has traditionally happened. And if we talk about the next slide, the Federal Land Policy Management Act of 1976, this is really where Congress tells the executive, how it is to do its job in managing the federal lands. it's called the kind of the organic act of the Bureau of Land Management. In layman's terms, that's basically the guiding document of how the BLM, through the Secretary of Interior, is to do its job. What is the goals of Congress in passing what we call FLIPMA, and how must the Secretary of Interior do his or her job? Critically, as you can see, the public lands are to be managed in a manner that will protect the quality of scientific, science, historical, ecological, environmental, air, water, and archaeological values. But added to that, and quite importantly, the public lands shall be managed in a manner which recognizes the nation's need for domestic sources of minerals, food, timber, and fiber from the public lands. And it requires that the United States receive fair market value for the use of public lands and their resources, unless otherwise provided for the statute. So troubling to many of us here is that these executive orders have a negative impact potentially on the expressed congressional intent to actually develop the nation's mineral resources and to receive fair market value for them. Personally, by not leasing the minerals, it becomes difficult to see how the government would be able to allow for their development and to receive the fair market value for its resources, and as dictated by the Federal Land Policy Management Act. Eric's going to get into a little bit more on what FLIPMA means when it comes to regulating lands. I just want to briefly mention that FLIPMA does compel the BLM to engage in comprehensive land use planning, basically determining how particular lands are going to be used over a 5-year period. And that is a very important part and piece when it comes to this oil and gas leasing utilization standpoint. So if we go to the next slide. And like I said, I'm going to keep mine pretty short. I think you're going to find the information that Eric Waeckerlin provides is very, very informative. But the question is, well, what can Wyoming do? We're all in this boat. We're all troubled. The first I put is advocacy. The Secretary of Interior, as we've seen through the FLIPMA provisions, the Mineral Leasing Act provisions, has a lot of discretion sometimes. So there is a current nominee. I don't want to pronounce her name wrong. I believe it's Deb Holland or Howland. She's from New Mexico. The hope would be that she realizes these impacts will be very concerning to her home state of New Mexico. So advocacy is a very important piece here. Litigation. Are these executive orders lawful? And I think that's a question a lot of you want to know. There was a lawsuit filed last Thursday, I believe. It was filed by Western Energy Alliance in the District Court of Wyoming. Eric's going to discuss a little bit more of that lawsuit. It's case number 21 CV0013. I'm not sure whether it's been appointed to a specific federal judge at this point, but the case is filed seeking to challenge those executive orders. Certainly Wyoming and might have a seat at that table because we certainly have are impacted by these orders. There's also a congressional action standpoint. I know that Senator or Representative Cheney and I believe both senators have co-sponsored legislation basically to ask that the moratorium be ended. Certainly that would be helpful when it comes to a federal development standpoint. And so I do think that there's a lot of opportunity for the state to look at those various avenues. The last question would be, well, could our state itself address some of these issues? And you know, it's hard because the property clause of the Constitution vests authority to regulate the public lands in Congress and the federal government. But Wyoming does have a lot of lands and minerals that might not be federally owned. So we did have a question arise before this conference that came in on drilling units. And so I do think there's potential avenues that our legislature and Oil and Gas Commission might want to look at when it comes to say, well, you know, how can we incentivize oil and gas development in light of these orders? One potential avenue, and it's certainly not ideal, but maybe we look at changing the way we do drilling and spacing units. That's to say that in the Powder River Basin, where you have kind of a hodgepodge of federal mineral interests. Maybe we need to look at allowing our operators a little bit more freedom in the drilling and spacing units that they create. Maybe allow a little bit more freedom in what might be their surface hole locations, so they could drill wells that aren't going to include federal minerals. Now, that's certainly not ideal, because the state of Wyoming gets the 6.25% royalty, and we certainly would like those federal minerals developed. But still, Wyoming does have severance taxes, and we'd love to see the private minerals developed as well. So I do think that there is some opportunity to look at that. Colorado has a Rule 318A for overlapping drilling and spacing units, which allow basically operators a little bit more freedom in surface locations and forming units. And in Colorado basically did that out of necessity in its urban environments that allow you to create a little bit different and overlapping units. So as I indicate, that's not ideal, but it is a potential avenue to look at. And so, there's a lot of questions, I think, and Eric Waeckerlin, I think, is going to provide a little bit more information. And unfortunately, we can't just provide the best answer and here's what we do. So with that said, I'm going to hand it over to Eric Waeckerlin, and I thank you all for tuning in.
Thanks, Chris. Appreciate that. And good afternoon, everyone. Let me pull up my notes here. It's a pleasure to talk to you all. I wish it wasn't such a sobering moment. I think, Chris and the folks at SER asked me to talk about the litigation and a little bit about what we've been advising our clients over the last week, really, since the executive order came out. And I think the bottom line, unfortunately, is that there's just going to be massive uncertainty for a while. There's not a whole lot of great answers right now. We're all kind of navigating these uncharted waters and trying to figure out, what comes next as the administration transitions here. So I'll get into the litigation and some thoughts I have about what folks might be doing for now. But before I do that, I wanted to just quickly talk a little bit about the reality of the situation and the problem that we're trying to solve here. This EO and administration effort is clearly directed at climate change. Biden's political appointees to date have a deep background in climate change, and it's clearly the overwhelming focus of both the EO, the pause on the federal oil and gas leasing, and Secretarial Order 3395 that Kipp mentioned earlier, that pauses or at least removes delegated authority for 60 days. So I just wanted to touch briefly. I think it's important to talk about all of this in context, because context is important. And what is the data telling us on the climate change front? Well, the data says that the United States is already leading the world in reducing greenhouse gas emissions, due in significant part, frankly, to clean production of domestic oil and natural gas resources. From 2005 and up on the screen here is EPA's own data from their greenhouse gas inventory report. Data goes up to 2018, but the trends are similar. But what you see there is from 2005 to 2018, CO2 emissions fell 12% across the country, economy-wide, compared with energy-related CO2 emissions globally over the same time, which increased 24%. So the EPA data consistently, and I've shown this chart in various iterations over many years, and it's clear that EPA's own data is showing a persistent and significant decline in CO2 emissions since 2007. Next slide, please. This slide is also from EPA's Greenhouse Gas Inventory Report from 2020, which includes data up through 2018. And what this is showing you, and why I think this is important, is CO2 is obviously the most ubiquitous greenhouse gas, right? It makes up over 80% of the greenhouse gas pie. But methane, which we worry about most in the oil and gas conversation in terms of climate change and greenhouse gases, is a much smaller portion of the overall greenhouse gas emissions. But it's important because it has a higher global warming potential over shorter period. So it's a more intense climate driver, even though it's a smaller percentage of the greenhouse gas kind of makeup. Next slide, please. So I want to talk about methane because that's really, in large part what we're talking about here in the context of this executive order and the climate change initiatives from the administration. What do we know about methane emissions from oil and gas systems in the United States? Well, this industry has a remarkable success story, frankly, to tell with respect to methane emissions. Oil and gas petroleum system methane emissions are down nearly 25% since 1990. This quote, again, comes from EPA's own data and EPA's own report. And you'll see in there, and according to EPA, this is because of more and stronger regulations, both at the federal and state level. These include leak detection and repair programs, tighter air control standards and requirements, and a focus on upgraded and better equipment. So I completely agree with Dr. Considine. I don't think it's any stretch at all to say that the domestic oil and gas industry in this country, including Wyoming, produces by far the cleanest oil and natural gas in the world, anywhere in the world. I raise this because if you listen to critics and the chatter kind of out there as we transition to this new administration, you rarely hear about these facts and these data. So the point to me is not that there's not more to be done, and it's not a comment on climate change or anything like that. Rather, it's critical to put the problem in context and to talk about facts and data and what they're telling us. And I'll just note, this isn't just an environmental issue. Obviously, it's a jobs issue, as both Chris and Dr. Considine mentioned, which, by the way, carries its own environmental justice considerations when you're talking about putting 30,000 to 50,000 people out of employment every year. And it's also a national security issue. So I know you didn't come here to hear me say that, but I think it's important to put all this in context when we're talking about the executive order and the administration's recent moves here. So let me talk a little bit about what the litigation might look like, and then I'll transition to what operators might be considering in the meantime. So next slide, please. Last Wednesday, as Chris said, Western Energy Alliance filed suit in federal district court in Wyoming over the executive order, over the leasing pause, a few minutes after the EO was signed, frankly. And I think I just saw today that case has been submitted to Judge Skavdal in Casper. So I don't represent Western Energy Alliance on that particular case. I have represented them and do represent them in an appeal on the venting and flaring case. It's currently in front of the 10th Circuit. And I'll just say that Judge Skavdal is the judge that invalidated both the Obama hydraulic fracturing rule as well as the Obama venting and flaring rule in the litigation I'm involved with. So at this point, I just want to talk briefly about that litigation. Chris gave you the docket number. If you go there, you'll see a one-page petition for judicial review. So there's not much out there yet. You're not going to be able to see a whole lot from the docket, but what is this litigation going to look like, and what are some of the issues that are going to come up? Well, first of all, a quick comment about challenging executive orders. And again, I'm just talking about the executive order and the lease pause. It can be difficult to challenge executive orders. You can see the language on the slide from the order itself that was issued last week, which appears to preclude judicial review and such a challenge. But there is case law, specifically some case law out of the DC Circuit in 1996, Chamber of Commerce v. Reich, where courts have allowed judicial review of an executive order where it contravenes a constitutional or statutory right. Essentially, the theory there would be that not even the president has the authority to order something that's unconstitutional or contrary to statute. I just raise this quickly. I don't foresee it being a huge issue because I think we're almost certain to see an implementing secretary order from the Department of Interior here shortly within the month. And I'll talk a little bit about challenging that order, but I do think it's worth noting that the executive order and the administration and the folks that wrote that chose their words carefully and deliberately. It talks about a pause. It does not talk about a ban. It has the words "to the extent consistent with applicable law." all of those words can make challenging that executive order difficult. So what will the litigation over a secretarial order that we haven't seen yet, but we're almost certainly going to see implementing the executive order, what's that going to look like? Secretarial orders that establish policy, departmental policy, are typically not reviewable because they lack final agency action. That said, you can look to the coal leasing moratorium that we saw several years ago, where courts found standing for parties to challenge what's going to happen here, which is a programmatic environmental review that may predetermine future decision making. So in other words, that court held that even where you have a secretarial order that issues a programmatic environmental review, you can still challenge that, even though it's may not necessarily be, in other contexts, final agency action. And I'll note that there's important differences with that case in 2019 and that coal leasing moratorium that the lawyers are going to have to address. But I think it's important to frame that. Next slide, please. Perhaps more importantly for challenging the secretarial order, the Administrative Procedure Act itself allows for challenges to agency inaction, where the agency has a statutory duty to act. There's already helpful case law out here directly on this issue where Western Energy Alliance is involved. The litigation that these quotes come from revolved around BLM's failure to hold quarterly lease sales in New Mexico, primarily in New Mexico, but also other states. And they come from an opinion on the motion to dismiss stage. And there the court found, one, that the MLA, the Mineral Leasing Act, does not provide discretion to the secretary not to hold quarterly lease sales if eligible lands are available. So in other words, you could spin it another way, the court found that BLM has a non-discretionary statutory duty to act here in holding those lease sales. And two, the court found when BLM fails to hold these lease sales, there has been an injury at least sufficient to convey standing on the parties to bring that challenge. So important that these were on the motion to dismiss stage. They weren't on the merits of the claim. Nonetheless, I think they're instructive in terms of how at least one court has viewed BLM's statutory authority and discretion under the MLA. So what are we likely to see on the merits of the litigation? Well, that's, there's a lot to come, right? The fight's going to be about the controlling statutes, the MLA and FLTMA, as Kris laid out, and whether those mandate BLM to hold quarterly lease sales for leases deemed eligible for sale for lands available for sale, or whether BLM has sufficient discretion to put those on hold pending a programmatic review indefinitely. I think the outcome's difficult to predict. I'm not going to try and do that. But I will note a couple things. BLM has used the programmatic environmental review program in the past through their land use planning amendment authority to look at various issues. And two, the government as a general matter is acting at the height of its power when it's using its police power to protect public health and the environment. So I think the lawyers are going to have to contend with those two issues in this litigation. Next slide, please. As I mentioned, the administration has been really careful thus far in how they've couched this issue and talked about it, calling it a pause, using the words "to the extent consistent with applicable law," and generally framing the issue in terms of public health and the environment, which kind of all on their face nominally equate to not a ban. Now, practically speaking, I think you can make the argument that's where they're headed, but I just will say they've been careful about it. In thinking about this issue and trying to figure out what's going to happen, I think it's instructive to look at what several of the environmental groups have already laid out on this topic. There's a link here to Center for Biological Diversity petition for this exact kind of moratorium on oil and gas leasing up here, as well as a Wild Earth Guardian petition. And not surprisingly, you read these petitions and the case that they make is that the Secretary of Interior has significant and broad discretion under both MLA and FLTMA to hold lease sales pending a programmatic review, going so far as to say that discretion extends to not only when and how to hold a lease sale, but if at all a lease sale should be held. They also make the claim that FLTMA allows BLM to withdraw programmatically from consideration new federal leases. I don't think FLTMA is anywhere close to that broad. I think that statute's much narrower and forecloses essentially using FLTMA to withdraw all the entire federal leasing program. It really limited, not expanded, the Secretary's authority in that respect. But those are kind of the issues that are likely to come up in the litigation. Those are what the environmental groups, and I would expect to some degree the government is going to be saying when the litigation gets to its merits. Next slide, please. So I thought it might be helpful quickly to talk about what the programmatic environmental review might look like. And I think, it's obvious that the whole thing is going to focus on climate change and greenhouse gas emissions. That may not be everything, but that's going to be the central focus. And this was essentially the scope of the programmatic review the Obama administration did for coal leasing and the coal leasing moratorium. So I think it's helpful to look at that in terms of what the scope might be. And I will just note here that I think, unfortunately, part of the tactic is delay across the board. And, looking at how they rolled out the programmatic review for the coal program, it took them a year even to get to a scope. So, that would be a year from now just to kind of lay out these 6 bullets on the scope for this programmatic review. And I think it's also, important to mention the issues of social cost of carbon and social cost of methane. You'll recall that under the Trump administration, they revoked the prior administration's kind of view of the world on social cost of carbon and social cost of methane, and put in place an interim social cost of carbon and methane, which plays a really, really important role in the outcome of any kind of environmental assessment when you're looking at a cost benefit analysis. And I'll just give you an example that I know very well from the venting and flaring case, which is if you apply the social cost of carbon in a method in a way that accounts for global benefits. So basically you look at the reductions that are going to be at issue, you extrapolate the benefits globally. It makes that rule work out from a cost benefit standpoint. But as soon as you apply that only domestically, so you're only looking at the benefits and costs at a domestic level, that rule completely flips, and the costs outweigh the benefits by quite a bit. So this is a really key piece to what this new administration is going to be doing. And the other data point I'd share from the venting and flaring rule is that when they put that rule in place, it was really it had a large air quality component to it, and even when they were talking about the emission reductions that were going to come from that rule, had it gone into effect and played out, you were talking about, I think, 0.61% of greenhouse gas emissions. I think at the global level, that was domestically, and even less at the global level. So you're really talking to, in terms of air quality, emissions perspective, from a rule that was already on the books, in terms of reducing emissions from this industry, you're talking far less than 1% emissions reduction. So just something to think about. I think one big question is what comes out of the programmatic review. I mean, it's uncertain, right? You can see what Center for Biological Diversity thinks should happen right there. That their remedy is that there will be no public lands considered eligible or available for leasing if it's not consistent with the United States goal of limiting climate change to 1.5 degrees Celsius. I think that approach is clearly calculated to ban future leasing, and is hopefully not the outcome here. Potential more likely outcomes include, leasing limited in number per lease sale or geographical extent, leasing postponed in certain places pending updates to resource management plans or EISs that maybe the Secretary finds deserve more full consideration of climate change impacts, including downstream combustion. I think you're likely to see a call for more regulatory pressure, particularly on the EPA side, to regulate existing sources and emissions from existing sources. And of course, there's a call in the executive order, and I think it's going to be a big focus of this whole issue, which is to increase royalty rates to offset what they're surely going to find as, environmental costs associated with development. So, and as I said before, I mean, I think the key variable is how long it's going to take to get there. I think they can kind of take as long as they want. And so, I think part of the key here is devising a strategy that really couples the harm that's associated with this delay with some pressure to move quickly on this environmental review. Next slide, please. And I'm almost done here. A couple of things that I think operators can be doing. First, I want to talk about Secretarial Order 3395, which was the order issued on January 20th that it didn't pause leasing. It removed delegated authority from the field offices and elsewhere and put it with this acting secretary so that APDs, rights of ways, a bunch of stuff, bunch of approvals can no longer at this point for 60 days anyway be approved by anyone but the secretary. So I've talked to a lot of folks. I've asked for a lot of opinions. There's a lot of uncertainty, unfortunately, out there. It looks at this point that some downhole sundries that don't trigger NEPA review are getting approved. But I will note that there were a number of operators that had APDs issued, that kind of routine APDs that were basically just at the signature stage, issued after that secretarial order came out. So like, a day or two after, which were subsequently rescinded for a lack of sufficient authority. On those, if you fall into those buckets, keep in mind that the APA, the Administrative Procedure Act, says an agency cannot unreasonably delay or withhold required action. Onshore order requires a completeness review of APDs within 10 days and then an up or down approval or denial within 30 days. So that could serve as kind of the first step of some litigation. The other thing I mentioned about that order is that there's exclusions there. So where operations are necessary to avoid adverse impacts to public land or mineral resources, and there's also an exclusion for public health and safety, they're allowed to go forward. So I think I've encouraged clients, operators to look for places where implementation of the order strand or waste mineral resources, perhaps by forcing operators to pursue non-optimal drilling plans and get less production. That could be adverse impact to a mineral resource. Or if a withheld APD will force an operator, to move locations and potentially increase environmental impact, like increase flaring because they can't tie in, or build new pads and increase surface disturbance. So think about those in your operations. And then the last thing I'd say is this is not a no, this particular order. While it's in place for 60 days, and I suppose they could always extend it, it removed delegated authority. So continue to seek approval at the necessary level. Consider writing letters to the secretary or acting secretary. Copy the secretary or acting secretary on important submittals that you need approved, and just kind of work it up the chain, starting with the field office and then go up, particularly if it's critical and time sensitive. Okay, last slide, please. So what can operators do during the pause of federal leasing during the programmatic environmental review? I mean, I think that's a more difficult question, mostly because we don't really know what that implementing secretarial order is going to say, nor do we know, the scope of the review or how long it's going to last. But I think a couple things to think about, and I really think about this in terms of kind of assessing your company's overall risk for an extended pause, not knowing the time or the outcome. Consider, reviewing your drilling plans to identify where there may be heightened or unusual environmental risk, like a lack of gathering infrastructure or need for flaring, other unusual disposal or water resource impacts, things like that. Those are going to be the most likely to be subject to delay once the programmatic review is over, and it might provide you kind of a jump start on changing or altering drilling plans or locations, shuffling your programs around to avoid this risk, giving yourself the best chance at moving forward in light of an uncertain landscape here. Yeah, I don't think it's any secret that flaring is going to be a major focus. So, you know, to the extent you can review your program for flaring issues, that's probably worth doing too. Similarly, identify RMPs or EISs that may be in areas that are outdated, particularly where those may not fully consider climate change impacts through the planning stages. I think those are going to be squarely in the target during this programmatic review as a vehicle to kind of further delay development, and for DOI to potentially make a finding that that those lands are not available in those RMPs for leasing. Obviously, I think it's just going to be more stringent regulation and additional emission reductions and COAs in your APDs and increased lease stipulations really around emissions. So, you know, I guess I'll end here with kind of what Chris said. I mean, in all of the speakers said, I think it's important to actively participate in this process. It's going to be critical for the industry to constantly think about making the record to help guide the programmatic analysis, as well as department decisions along the way, as the administration has promised to continue development on valid existing leases. And so I think it's going to be particularly important to develop that record and develop your record of harm where it exists. And I'll just give you an example of why it's going to be critical to get in there and fact check what's going on. In WEG's 2016 petition, it relies on 2010 data essentially to make the case that this industry's climate and emissions impact. And obviously we know the entire world, the entire regulatory landscape, and the emissions profile, not just in this industry, but more broadly, is totally different from 2010. So it's really important when they're looking at the environmental impact of what's going on, that they're using the best and most recently available data to assess, you know, what needs to change as a result of climate change emissions. So with that, I will stop talking. I really appreciate your time and look forward to questions.
Eric, thank you very much. So at this point, we're going to close out the program just with a couple questions. We've had a lot of questions that have come in, and obviously we're not going to be able to get to all of them, but if we could have all the panelists just briefly come back on. And while they're on, Eric, I'm going to lead off with a first question for you. And the question is this: are tribal lands and their associated minerals affected by the executive order's leasing restrictions?
Thanks, Kipp. So the executive order itself is silent on tribal lands. The fact sheet that accompanied the executive order the morning of the announcement made clear that it's not the intention to include tribal lands. And I know Chris deals with this a lot too, so you might want to weigh in, Chris, too. I mean, I think the reality is that they're not going to be included on the face of these documents and in the secretarial order, but as a practical matter, you know, whether you're going to implicate tribal lands with adjacent leases that you might need for your drilling program, or, you know, a whole host of other issues that surround kind of development of units and the use of federal leases, I think as a practical matter, as it plays out, are bound to affect tribal lands.
Yeah, Eric did a great job explaining that. I'll just expound a little bit. Tribal lands are actually leased pursuant to the Indian Mineral Leasing Act of 1938. So not necessarily the MLA. What's important to keep in mind when you're talking about tribal lands is that tribal lands is a different kind of ownership than we're accustomed to. Generally, we say title to tribal lands is held in trust by the federal government for the benefit of the tribal populations. We do have a Supreme Court case that indicates that the United States must manage those minerals for the benefit of the tribe. So it's a bit of a different circumstance. Tribal leasing is often managed through the Bureau of Indian Affairs, the BIA, but but you do need typically Secretary of Interior and BLM approval. So there is Interior and BLM involvement there, but it's generally through the BIA. I think one of the bigger impacts is when you look at when the BLM or Interior decides whether to issue a tribal lease, that will trigger what we call NEPA, or National Environmental Policy Act, and ESA review. And so if the Biden administration or the federal government wanted to prevent oil and gas development on tribal lands, it might have a big stick there through ESA and NEPA. So hopefully that helps clarify that a bit.
Very good, Chris. And a question for you, and we are almost out of time, so I'm going to ask you to be very brief. The next question that came in was, does the executive order affect development on already leased federal minerals?
Well, if they're already leased, we're not asking the question, is that parcel available for leasing? But keep in mind that there are leases that, in the way federal leases work, is you drill a well, and once a well is drilled, it continues for so long thereafter as oil and gas is produced. So if you didn't drill a well on the lease in the primary term, your lease would terminate, and you would certainly need to acquire a new lease. I do mention that the federal leasing isn't generally done on kind of a large block. Rather, federal leasing is kind of haphazardly, where operators tend to have to pay attention to see the upcoming lease sales, so they can acquire all the federal leases they might need in a given area over several years for their project. So I guess the answer is yes and no. In reality, a moratorium on federal leasing is probably going to impact pretty much any project, at least in the Powder River Basin or western areas of Wyoming.
And I think it disproportionately impacts smaller companies. I think is the reality of that really rely on, that they don't have a bunch of leases or APDs that they rely on. And it's kind of like a paycheck to paycheck approach, right? And those are the companies that are really going to get, affected by this, I think.
So thank you very much. So we are almost at the top of the hour, so I'm going to close this out. So on behalf of the School of Energy Resources, led by Dr. Holly Krutka, the Executive Director, and myself, the Center for Energy Regulation and Policy Analysis, we would like to thank our panelists so much for this very informative program. We would also like to thank all of you in the audience for participating. And I would just like to close with a couple of observations that SER and CERPA, we get up every day trying to work hard for the benefit of the energy economy in the state of Wyoming, both fossil and renewable. And as we're in this transition, so SER and the Center for Economic Geology Research, they're doing great work on carbon management and CCUS and CO2 EOR. Just 10 days ago, BLM approved a record of decision for Wyoming Pipeline Corridor Initiative, which envisions the potential future expansion of the existing CO2 pipeline network in Wyoming. We're doing the geologists at KAGR are doing a huge amount of work on the characterization and identification of rare earth elements, both in produced waters from coals. Much of that is on federal lands. So we're envisioning the day coming as renewables increase our penetration, and we want Wyoming to be playing in that as well. So we're worried about the impacts of this on our work on the carbon management and renewable side. But with that, I thank you all, and check the SERPA website for more information. And I think that's a wrap. We're done. Oh, one more, please, excuse me. A special thanks for Christine Reed, who is the SER Publications and Outreach Coordinator, who just did a huge amount of work of putting this complicated program behind the scenes. So Christine, a shout out of thanks to you. We're done. Thank you all very much.